Court is now in session. Please be seated.
And for the record, I'm Justice Eric Nyman. Sitting to my right, Justice Sook-Young Shin. Sitting to my left, Justice Paul Smith. Calling our second case today, docket 21P981, Commonwealth versus Fuentes. We'll hear first from Attorney Griffiths.
Good morning, Your Honor. May it please the Court, Darren Griffiths on behalf of Alfredo Fuentes, the defendant in this case. The cumulative weight of the uncharged criminal conduct introduced in this case overwhelmed the charged conduct, and that quantum of evidence, along with the Commonwealth's closing argument, which blurred the lines between uncharged evidence and charged conduct, played out and also played to the jury's sympathies, deprived the defendant of a fair and impartial trial on the merits of the conduct for which he was charged in this case. Those errors were then compounded by the judge's instructions to the jury. Turning to the first issue that I raised in my brief, the prior bad act evidence. I think the law in Massachusetts is clear. Despite exceptions that have been carved out and developed over the years that do permit some prior bad act evidence, there's still a clear prohibition against using prior bad acts as propensity evidence. And the admission of such evidence carries with it a very high risk of prejudice to the defendant. Now, here we had a number of bad acts that were introduced, prior bad acts that were introduced.
Was this issue properly preserved? I know it was raised in a motion in limine, and that transcript at pages 30-31, there's a discussion. But was the objection that was made by defense counsel during the motion in limine the same as the argument you are now making on appeal?
I do think it is, Your Honor. I do think what the argument that defense counsel was making during that discussion on the motion in limine was regarding whether or not this would have an undue prejudicial impact on the defendant and the ability of the defendant to have a fair trial. And I do think
there was interesting because it's the attorney who. It's not you. The defense counsel at trial said in response to the judge's question as to any reason I should keep these out, said just that these are being used to support the charges, and these statements have consistently varied over the course of the investigation and the course of the pendency of the trial. And then defense counsel went on and said the elaboration of additional statements as to what the nature of their relationship has been continued to grow, whereas the statements as to the charged incidents have become less consistent. And defense counsel went on, and sort of the focus of the objection pre-trial was that the evidence of the charged conduct varied, whereas the evidence of the prior bad acts was a more consistent story. That strikes me as something that's distinguishable from the argument you're making on appeal.
Well, I do think what the attorney was driving at, and maybe didn't drive the point home quite as well as they should have, though, what they were driving at was that the quantum of evidence that was being introduced would basically amount to propensity evidence. And I do think that's the risk here, and I do think even under the substantial risk of miscarriage of justice standard, I think we have a significant issue here regarding the fundamental fairness of this trial, especially where the trial court, the trial judge, did not do the balancing. There was no evidence that she did the balancing and weighed the probative value of this evidence that the Commonwealth intended to introduce during the course of the trial against that prejudicial impact of the defendant. What she stated on the record, and this is clear from the transcript, was that she did think that there was a permissible purpose here, but what's missing from that evaluation of this potential evidence is that second piece. It's really important, and I think the case law makes it clear that that second piece is really important when we're talking about uncharged conduct, prior bad act evidence. It's clear that you have to look at the prejudicial impact, and that was never done. And I think that's very clear from the lack of discussion of the potential prejudicial impact from the judge at any point. In fact, I think it's also significant that not only was there no discussion sort of before, during the motion to eliminate argument, but there was also no discussion during the course of the trial. In fact, At one point, there was sort of during a sidebar or a conversation between counsel and the judge, there was I think a cataloging of these events of uncharged conduct. But again, at that point, the bell had been rung at that point. All of this evidence had already been introduced, and we have a sort of post hoc discussion trying to sort out what these different acts of uncharged conduct were, but no consideration of whether or not this had a prejudicial impact. And again, I think Creighton and other cases that have looked at this issue make it clear that that is definitely a necessary step, and it just was not part of the analysis here.
Well, it's not an implicit part of the analysis.
I do think the case law is pretty clear that there needs to be some evidence or some indication on the record that there is some weighing of this evidence. And again,
So all she had to say on the record was, I find the probative value outweighs the unfair prejudice, and that would have been okay?
well, I think she would need to indicate why she believes the probative value. I think there would need to be some indication of how that weighing is actually being done, not just that, not just sort of regurgitating the standard. There would need to be I find that
The case law requires the judge to go further and explain exactly why.
I believe there is. I believe if you look at, for example, the Harris case, I think there are a couple of different cases that cite two cases where there's no discussion by the court of this weighing. I think they raise the issue that this simply is not enough. And that those cases are cited in both Fasella as well as in Dwyer. They both indicate that this sort of, in order for this evidence to properly be in front of a jury, there needs to be some evidence that the weighing is actually being done. In addition, I think the second piece of this is that the evidence regarding the prior bad acts was actually testified to in far too much detail. And I think there's case law indicating that when there's prior bad act evidence that's going to be admitted, that going into granular detail about the uncharged conduct is unfair. One, because it basically forces a defendant to defend against charges that were not raised in the indictment, and it also, again, tips the scale where the weight of that evidence has a dramatic ability to outweigh what is actually supposed to be in front of the jury and what's supposed to be considered by the jury. And I think there's a suggestion in Dwyer and Fasella that when this type of uncharged conduct is going to be presented, that it should be explained in a summary manner, not in the manner it was presented here, where for example, the testimony regarding the Dorchester incident that was on the bed, that was more detailed and explicit than some of the testimony regarding the charged conduct that was actually admitted during the course of the trial. And we have 4 different times when the victim testified about being touched in the shower improperly by the defendant. 4 different times. So we have not only a cumulative weight, but we also have very specific and graphic evidence that I think, again, is introduced in much more detail than is permissible. And I think the reason, again, another reason why that is a problem here is because it shifts then the focus away from the charged conduct. That's the subject matter of these indictments. And it shifts the focus actually to this uncharged conduct. And we see that during the course of the trial here, where not only do we have cross-examination from defense counsel regarding this uncharged conduct, which I think there's, when you're in that position as a defense attorney, you have no choice but to try to cross-examine an alleged victim on that particular conduct. But we also have direct examination from defense counsel related to that uncharged conduct. And we have, again, cross-examination then by the Commonwealth related to that uncharged conduct. So we have sort of a cascading effect. And what we have is sort of these little mini trials regarding uncharged conduct. And again, the weight and the focus of the trial moved away from the subject matter of the indictments, and again, focus squarely on this uncharged conduct. And again, you see this highlighted again in the closing arguments from the prosecutor. And again, I think the case law makes it clear that when we have uncharged conduct, it's incumbent upon the prosecutor not to go into, not to emphasize or highlight that uncharged conduct in the closing arguments, but that happened here.
Was there, I have two questions.
Yes.
Am I correct that the prosecutor twice referenced the prior bad acts evidence, and that's at volume 4, pages 138 and 143?
Yes.
Was there any objection to the closing argument?
There was not.
Would you agree that, I know that your position is that the issue is preserved as to the evidentiary portion of the trial?
Yes.
What's your position as to our standard of review as to the closing argument?
So I do think it's a substantial risk of miscarriage of justice. But I do think, again, where we're talking about, this is not only, it's not an error that occurs in a vacuum, right? This is an error that occurs within the larger context of all of this evidence, this quantum of evidence being introduced during the course of the trial and then compounded by this mistake. And again, that affects the fundamental fairness of this trial. And I do think, even under this substantial risk of miscarriage of justice standard, I think there is a real problem with the fairness of that closing argument and the way in which, especially the uncharged conduct and the charged conduct was intertwined and interlinked by the prosecutor. And then that was also compounded further by...
You're not challenging that part of the closing independently, right? You're saying that it contributes to the prejudice caused by the admission of the prior bad acts evidence. Is that accurate?
I don't think the two can be sort of separated. I think because of all this prior bad act evidence that had come in, I think that the unfairness of that evidence was then compounded by the closing argument.
And I don't see you making an independent argument under the substantial risk standard that part of the closing was improper, standing alone.
Well, I do think it is improper standing alone, but I also think that it can't be considered in a vacuum. And I also think you also have to look at the totality of that closing argument, where we have a number of other errors, including what I would argue is vouching for the victim's credibility, as well as it appeals to the jury's sympathy by the use of this photograph that during a motion in limine, the Commonwealth very specifically said that they were only going to use for a limited purpose of establishing the age of the victim at the time of this offense. Here, in closing argument, we have a very different use of that photograph.
We see, I'm sorry to interrupt, but we see in the transcript that the prosecutor asked for the exhibit, which ostensibly is the photograph.
Correct. I think that was the only exhibit introduced.
Right. Is it clear from the record as to how long the prosecutor was holding up that exhibit during closing?
It's not clear. It's not clear, but I think what's clear is the language that's used by the prosecutor during the course of that argument. And that argument, that portion of the argument basically asks the jury to imagine this victim at the time and imagine that, here she is at the time she's having to make these decisions about disclosing this alleged abuse to her mom. This is how she looked. This is the way in which, this is sort of the developmental stage at which she would be in at this time. And again, that's an appeal to the jury's sympathy, I think, very clearly. And again, improper in closing argument, and especially improper.
I just have a quick question on that. And again, I believe there was no objection to this, correct?
There's not.
Is there a difference in terms of our analysis between a prosecutor holding up an exhibit, in this case the photograph, and holding it up briefly, showing it to the jury, and then continuing with argument, and the prosecutor carrying the photo and speaking with the photo in hand, let's say, for 5 minutes of a closing?
I certainly think.
I think there is. It would be
yes.
helpful if there's clarity from the record as to which occurred here. The former strikes me as possibly de minimis. The latter strikes me as problematic.
Yeah, and we don't know, but I think the tenor of the argument that was made during this portion of the transcript, I think, may lend some credibility to the idea that the prosecutor was holding this photograph during the portion of this argument. And I do think this is not simply an isolated error here. Again, we're talking about a cumulative effect of a number of
Your time has expired, but I'll let you finish your thought.
It's a cumulative effect that also, it sort of plays on the jury sympathies, and it also plays into the prosecutor's arguments regarding the victim's credibility as well.
Any further questions? Nope, seeing none, thank you very much.
Thank you.
We'll now hear from the Commonwealth.
Good morning, may it please the court, Brooke Hartley for the Commonwealth. This court should affirm the defendant's convictions of assault on a child with intent to rape and indecent assault and battery. Unless the court has specific questions, I'll just take the issues in turn as my brother did. The judge properly allowed the evidence of the defendant's uncharged conduct, uncharged abuse of the victim for the very limited purpose of showing the nature of the defendant's relationship with the victim, showing an ongoing pattern of abuse, and showing absence of mistake.
Is this issue properly preserved through the motion in limine or not?
I'm not sure it was. I think I would disagree with my brother that his argument here is the same as the prosecutor's argument during the motion in limine. I think the prosecutor essentially said that I apologize, defense attorney essentially said that she agreed that this was relevant evidence based on the case law, but said that, first of all, I think she was questioning why it wasn't charged, which the prosecutor explained, and I think was perhaps worried about some confusion about the incidences of charged and uncharged conduct, which I would agree is similar to what my brother is arguing on appeal. But I would say that by either standard, the Commonwealth would still win, Your Honor.
If the argument is that the evidence was unfairly prejudicial because of the quantity and detail of the evidence, how do you raise that objection before the evidence is actually elicited?
I think that's a good point, Your Honor. I think there certainly still could have been an objection.
In that situation, is it incumbent on defense counsel to object at trial, to specify that the basis?
I think so, and to renew the objection perhaps on different grounds that were not possible at the time of the motion.
And so then what would happen?
If the prosecutor...
If the defense counsel objected, after the testimony came out, the defense counsel objects to the detail and quantity, what should the judge do then at that point?
Well, I think in this case, the judge nothing would have changed, but...
She would have given the same curative instruction.
Yes, I think the curative instructions here were more than satisfactory. Both one that was given, it was not contemporaneous, but it was given when the evidence was still being taken, and then one was given in the final charge to the jury.
But isn't it incumbent on defense counsel to object as the evidence is coming in? The judge hasn't heard this case before. The judge doesn't know what questions are coming. So as the details start to come in, isn't it incumbent on defense counsel to say, well, whoa, Judge, now we're getting into detail here on prior bad acts, and have an objection before all of the evidence comes in?
Certainly, I think so. I think that would have helped address the problem at the time, although, of course, the Commonwealth's position is that there is no problem with the way the evidence came in. First of all, I'm not sure my brother is disagreeing with the fact that it is relevant evidence because it occurred in the same time frame, common scheme, pattern of operation, intent, and I think most importantly, it gave the jury a view of the entire relationship between the defendant and the victim here. If the jury had been left with the false impression that this abuse just occurred twice during the period of 7 years, it would make much less sense why the victim was unable to remember.
Why was it necessary to go into so much detail about the uncharged act that occurred in Dorchester? I mean, so in about half a page of transcript, the testimony comes in that the victim testifies that the defendant put her hand on his penis and that he touched her breasts. Why was more needed than that? And then the transcript goes on for 2.5 more pages about the details of that incident. Why was that necessary?
So, Your Honor, I think in the context of all the evidence that came in, this was still much less substantial than the charged evidence. And I think if you compare this case to Dwyer, you can see
That's true, but it wasn't insignificant. I mean, I counted about 6 pages out of 36 or so. That's not insignificant.
certainly, it's perhaps not insignificant, but I think here we're weighing prejudicial value against probative value. There's no question that this is prejudicial evidence. The question is whether it's more probative than prejudicial. And the Commonwealth's position is that it certainly is. And again, I think the most important part is to create a picture for the jury of what was happening. This was a father figure that lived with the victim for 7 years. This was abuse that was reoccurring. It wasn't something that happened twice. And without that context, the jury would have been unable to understand why the victim was confusing details of incidents, why she had trouble remembering certain dates and times and specifics. So while perhaps 2 pages of questioning on that was unnecessary, I don't think it was over the line and created prejudicial evidence in this case.
Let's assume it's close to the line for the sake of argument. Is it fair game for the prosecutor to even mention it at all in closing argument?
Yes, I think so. I would note in closing argument that the prosecutor referred to this evidence twice, and that was 6 lines in a 12-page closing. I, again, don't think that these remarks highlighted the bad acts, but rather provided context for the victim's relationship with the defendant, and again, explained why the victim's accounts of the abuse were inconsistent at times. And I would also note, as I mentioned briefly earlier, that any risk of prejudice here was cured by the judge's very forceful limiting instructions. The first limiting instruction came on day 3 of trial at page 115, and this was during evidence. And the judge was very careful to delineate between the charged conduct and the uncharged conduct. She specifically told the jury what was charged. She then specifically listed the incidents of uncharged conduct, and she explained why the jury is not to consider the uncharged conduct as propensity evidence. She essentially gave a very similar instruction after the close of evidence, reiterating this for the jury, so it was top of mind as the jury went to deliberate. So I think the curative instruction addressed any potential issues if the court were to say that this were close to the line.
Are we to infer that the judge did the proper balancing that found that the probative value outweighed prejudicial impact? It was maybe odd that neither party referenced a balancing test during the motion. The judge didn't reference the test. How do we know that the judge did find that the probative value outweighed the prejudicial impact?
I don't know. I know my brother mentioned Facella. I think that's a murder case. I'm not sure it's exactly on point here, but I don't know of a case that says it has to be on the record that the judge did the balancing test. I think this court is free to affirm on any grounds that support the motion judge's decision, and I think that's implicit in the record. And I think when you look at the case law, if you look at Centeno, Newcomb, both from this court, with similar fact patterns, we can infer that a balancing test was done and that the right result was reached in this case. I don't think that needs to be on the record. Certainly it would have been preferable and helpful, but I think this court can come to that conclusion on its own. I can briefly address the closing argument and my brother's argument about vouching, not the...
Before you get there, is there any indicia, I asked your brother the same question, is there any indicia in the record as to how long the prosecutor held that exhibit for in front of the jury?
There's not, Your Honor. And I don't think we can infer or read into the record about how long the prosecutor was holding the picture up.
I want you to assume hypothetically that near the outset of the closing argument, The prosecutor asked for the exhibit, the photo of the victim at the age she was when the crime was allegedly committed. And the prosecutor speaks to the jury for the next, let's say, 10 minutes, holding the picture and saying things like, this is the person who had to process what was happening to her, and speaks to the jury holding that photograph for the entire closing. Is that problematic?
So I think that's a different situation than showing the jury the picture.
Right, so
Briefly.
that's why I asked you to assume for purposes of the
Yes.
question that the
Yes.
prosecutor held it for the entire argument.
And I understand it's a hypothetical question, but I would just, again, before I address it, suggest that we can't read that into the record. I do think that would be a different question. I think it would be quite close to the line, but I would also say in a case like this, a sexual assault case with a child, the case law is clear that we treat this type of case differently. If you look at Stewart from this court, it's an 2022 unpublished decision. The court says that child victims of sexual assault are particularly susceptible to delayed disclosure. Degree of flexibility is needed for the evidence. So I know that probably
How does
refers
holding
to-
up a photograph for 10 minutes as if you are the victim speaking to the jury assist the finder of fact?
Again, I
closing
think that would
argument?
be
If you were conducting, if
excessive.
you were making this closing argument yourself as the prosecutor, would you even dream of holding up a photo of the victim for your entire closing argument and standing in front of the jury holding it and arguing your closing?
No, Your Honor. No, I certainly
You
wouldn't.
dream of going back to your office and telling someone who's conducted that closing or conducting any closing that that's a good idea?
No, Your Honor. No, and at the very least, that is close to the line. But I would just highlight that in a case like this, we review it for judge's abuse of discretion. And a photo here in a child abuse case is different than a photo in another case, where the prosecutor was using this photo to show the amount of time that had passed.
How old was the victim at trial?
So I think she was about 15 or 16, and the abuse began when she was 6 years old.
And the picture was when she was 8 or 9?
Yeah, the picture was when she was 8 or 9. So it was being used to show, how much time had passed since the abuse, to show her youth, her immaturity, which was all relevant to the dynamic of this relationship. So again, I think the picture was not problematic. Perhaps holding it up for the entirety of the closing would be a very different story, but I don't think we can read that into the record here. And moving on, unless the court has further questions about the prior bad acts, to the closing, my brother argues that the prosecutor was vouching for the victim. And the critical question here is whether the prosecutor stated or implied that she had knowledge that the jury did not, independent of the jury, or asserted some personal belief about the victim's credibility. That's not what happened here. The part of the closing that my brother takes issue with, she says, "What reason is before you that the victim would be untruthful about this man raping her? What motive does she have to come before you and tell you that to put that on him? What does she gain by doing that? In the evidence before you, she gains nothing." And it goes on a little bit longer. But in this case, it's not improper for the prosecutor to defend the victim's credibility where that was a critical issue at trial, and especially where the defendant attacked the victim's credibility in closing. And again, I think the critical question is whether the prosecutor was implying that she had knowledge apart from the jury. Her rhetorical questions and the statements went directly to the evidence at issue in the case. And I am running low on time. I can briefly address the last issue, the judge's instructions to the jury after the question. So the judge properly responded to a jury question about what triggered the indictment by informing the jurors that they could only consider the victim's first complaint and that they had all the evidence. I would also argue that I'm not sure this was preserved. What happened was the judge read the question to the parties and then read what the judge suggested she was going to respond with, and the defense attorney suggested something else. And the judge said, "No, actually, I'm gonna read this instruction," which was Our rules normally permit testimony only as to the complainant's first report. You have all the evidence. After she said her final instruction, the defense attorney didn't object to that instruction. I think either way, the result is the same here. The first complaint doctrine permits one complaint witness, and that instruction was given to the jury earlier. This simply reiterated the instruction and in fact went beyond that by telling the jury that they had all the evidence and directing them not to speculate. There's no further questions, so I'll rest on my brief.
Seeing none, thank you. This case was well briefed and well argued. Thank you, counsel. The case is submitted. And calling our next case, docket 22P305, Department of Children and Families versus Mother. And before counsel begins argument, I'll remind you that this matter is impounded, so please refrain from using any of the parties' names, and please refrain from referring to any impounded material. We will hear first from counsel for the mother, Attorney Unger.
Yes, Your Honor. Good morning. May it please the court. I am Attorney Sarah Unger, and it is my privilege to represent the mother in this case. And a quick side note, no COVID, no RSV, I just have a lingering cough, so I'm happy to take this off if it makes me difficult to understand in any way. I just didn't want to cough on co-counsel at all. So,
if co-counsel doesn't object, that's fine. Either way, it's up to you.
So in this case, you're familiar with the record. You see that mother needed help. She needed help from the beginning, and she knew it. She was in a tough place when her daughter was born. This was her first child. She had no resources, no real support system. From the beginning, she asked DCF for help, and she asked for what she needed. She knew what would help her. She wanted to be admitted to a residential treatment program with her daughter. And looking forward into the case, this would have helped mother in 3 crucial areas that later came at issue in her action plan: homelessness, substance use, and visitation and bonding time. This would have really kick-started mother's progress in these areas. Instead, DCF decided, no, we're not going to give the thumbs up to that. You're on your own. Here's some lists. And things spiraled from there. Mother made a lot of good tries, but as the record makes clear, she kept failing. And this is because the department failed to make reasonable efforts when it would have helped mother, when it would have mattered, by giving her what she knew she needed at the beginning of the case. Now, there were opportunities later in the case for the department to make up a little ground, I guess. In some areas they did, in others they did not. Now, obviously the COVID-19 pandemic is not the department's fault, but their response to this afterwards. So there were 4 months, 4 crucial months at the beginning of this child's life where there was no visitation. Starting in May, so the child left the hospital in March 2020. Starting in May, there were some video visits, and even the court agreed, DCF agreed. These weren't their words, but basically these were worthless visits. These are not useful for a baby. Mother tried her best over
Well, when you say no visitation, that's not accurate. There were the video visits, correct?
There was video contact. I hesitate to call that visitation because, again, with a newborn, there's no skin to skin. There's some question as to how much is even perceived through a screen. There was no expert testimony, no testimony about that. So this is why I'm not referring to that as visitation. I'll call it contact. But yes, there's video contact, I guess. But after these 4 months, when there was no bonding, the department did have an opportunity to make up some ground. Instead, there were no unsupervised visits. There were no overnights. Again, these are things that would have happened had the baby been placed with mother at the beginning in a residential treatment program. But instead, the department compensated for this 4-month lack of crucial visitation by saying, okay, instead of 1 hour a week, you have 2 hours a week. This is great. And, that wasn't enough. 2 hours a week Totally.
Any indication the mother sought more than that?
She was constantly asking for placement with her daughter so she could have this overnight time, this live-in time. So she didn't use magic words, Your Honor.
The minor, the child was born substance affected. The mother had used a number of different drugs during her pregnancy, including fentanyl, correct? Cocaine?
Yes, yes.
So you're saying it's unreasonable for the department to ask the mother to recover and show a period of recovery before the minor was placed with the mother?
Yes, Your Honor. In this case, yes, because these programs are there for a reason. They have these residential treatment programs where mothers can go with their babies for a reason. It's because these mothers are using. It's because they were using during pregnancy. And the experts behind these programs, they know it's still a benefit to the baby to have their mother right there. And the fact that DCF didn't do that in this case was unreasonable. They weren't saying, mother wasn't saying, hey, DCF, please, let me go off with the baby into the wild. She was saying, I want to go into this highly supervised facility where there will be experts and medical people on hand 24/7. This is what she was asking for. It would be a different case if mother was complaining about, oh, you didn't just let me wander off with my child out of the hospital.
But she didn't actually enter that program, right?
Well,
When
she
left the hospital.
So she eventually entered Stepping Stone. So this is the program I'm referring to. She entered this in October 2020, and that's when things were a little shaky. She entered it, things were going fine. There was some indication that there was a conflict of interest, meaning a staff member knew her from the outside, nobody's fault. They signed her up for the New Bedford program.
That was, I'm just trying to get the timeline straight. That was several months after the child's birth, right?
Yes, Your Honor. So that was October 2020 when she's admitted to.
When you're saying the department should have allowed her to have overnight visits, that was earlier in May or so, right? But at that point, she was not actually in a program.
You're right, Your Honor.
Okay, so at that point, what more should the department have done? I mean, realistically, they could not give the child to the mother, right, at that point?
Well, realistically, it was still an option to have the mother in residential treatment with the child, so.
She wasn't in residential treatment.
Right, but for these programs, where you want to be in residential treatment with the baby, so there are different tiers of programs. There's detox, there's outpatient rehab, there's inpatient rehab, there's, what she wanted was basically residential treatment with her baby. So what she eventually was admitted to in October 2020 was residential treatment, but not with her baby. So we're missing that crucial point that would have helped bonding, helped her with her baby, helped the child. And again, let's look at the timeline. This is 4 months later. So this is 4 months too late, first of all, and it's not with her baby. So yes, she was in Stepping Stone, but this is a day late and a dollar short, much more than that. It's past the point where this would have helped in the early stages of bonding and gotten mother on track, off the streets, helped her get clean.
How long was she in Stepping Stone?
I think she was there for a few weeks. It wasn't long, but I don't want to misquote the record. I don't remember an exact time, but basically as soon as they discovered that there was this conflict, they transferred her to the New Bedford facility, and she didn't show up. But the record shows that the department kept falling down on the job. It wasn't just this initial failing. Now, that was the most egregious one. That's the one where they really could have set mother up to succeed in these different areas, and they didn't. But later on, when in-person visitation is resuming, she gets 1 extra hour a week. That's not going to be enough for her to make up for lost time with her infant, with her growing child. Other areas too, they could have gotten her into, even if they're not going to get her into the residential treatment at that point, they could have upped the visitation. And also in terms of homelessness. Now, this is another area where mother didn't use any magic words. She didn't file a motion, but it was clear what she needed. The department was aware throughout the case that mother was looking for housing, the social worker testified, yes, a mother was looking for housing throughout the case. She kept finding friends or people that she could stay with, or a broom closet that she could stay in, but the department knew that this was not working, this was not a solution, and it was in...
At the point in time you're talking about right now, does the mother have counsel?
So, that's another thing about the record. Officially, mother had counsel through the whole case, but her first trial attorney, I think from May to October 2020, she had filed a motion to withdraw. Basically, I think she didn't want to be in court during COVID. And so, there's little indication that anything happened on mother's behalf. So mother did have counsel officially, but this was, and this wasn't a perfectly handled case from any direction. That said, it's DCF's burden to show that reasonable efforts were made.
Don't our cases require motions? Because once the parents' rights have been terminated and we're now on appeal, the question is different, right? Now it's really about the best interests of the child, which is why it's incumbent on the parent to file a motion during the pendency of the proceeding.
That's true, Your Honor, but the guidance of Rashida explicitly wasn't available. And now this is a post-Walt case, but there wasn't as explicit of a guidance saying, like, listen, you can file this motion and the court will make this determination then.
Well, Rashida was just about visits, right?
I think so, Your Honor, but
It's my understanding there are many cases that say you need to file a motion if your allegation is that the department isn't making reasonable efforts.
if you want the court to address it, right, then that is the best way. But it still doesn't relieve the department of its burden of proving reasonable efforts at trial. And here, when it came to homelessness, when, you're right, mother didn't file a motion, she should have filed it, the counsel should have filed a motion, and she didn't do this. And yet, it's very clear to the department, it's in the record, it's according to the social worker's own testimony, that mother needed housing. Mother was looking for housing throughout the case.
Is that issue even preserved? Can you tell us how it's preserved for us, as well as the reasonable efforts as to her substance abuse?
So, the visitation was preserved. The substance and the housing were not preserved. But it still is something that this court should look at in determining, did the lower court abuse its discretion in finding that reasonable efforts were made here? And when you add up the sum total of all these DCF failures, it's clear that reasonable efforts weren't made. And not only did this hurt mother, but this hurt the child. Because when the department has an opportunity to have a child reunified with their biological parent and falls down on the job, then it's also the child that suffers. It's not just the parent. And you see these cases pop up again and again, and they're going to keep popping up because the department skirts in just under the line of, well, look, this parent was failing, and maybe we made a few mistakes, but they were always going to fail. Look how badly they started out. But that didn't have to be the case here. This didn't have to be the case with mother. She knew what she needed. She asked for it. The department denied her that. It was in their power to give her that. They denied her that. They denied the child that. And then that kept happening throughout the case. And in this case, if they had made reasonable efforts, again, it would have helped mother, but it also really would have helped this child. And the cases tell us that if we can't be confident that the lower court decided this with the utmost care, then we know that this judgment wasn't necessarily the best thing for the child. So I know the department places a lot of weight on, okay, well, maybe the department, even if the department failed mother, well, we need to look at what's best for the child. And yes, we do. But what is best for the child here would have been for the department to give her her fit parent, which was in their power. And in this case, just looking at the facts, It was not in the child's best interest for the department to fail to do so, and it was an abuse of
There was
discretion.
never a period of fitness. I mean, you're not contesting the initial finding, correct?
Correct, Your Honor.
When you say a fit parent, I mean, the mother struggled with a number of different issues, including being in a toxic relationship. The department couldn't have impacted that.
Well, actually, Your Honor, it could have. If it had put her in stepping stone at the beginning with her daughter, it also would have kickstarted her efforts to get away from her abusive spouse. And, later in the case, she eventually files a criminal report against him. He ends up being incarcerated. She struggles with that relationship through the lifetime of the case. But it shows that she was headed in the right direction. She was getting there eventually. She would have gotten there a lot sooner had she gotten off the streets, and that would have been affected by this, Your Honor. If there are no further questions, then,
Seeing none, thank you very much.
all right.
No,
Thank you, Your Honor. Thank you.
We will now hear from counsel for the appellee. My understanding is you're dividing your time, counsel for DCF 10 minutes, counsel for the child 5 minutes?
That is correct, Your Honor.
Attorney Peterson?
Good morning, Your Honors.
Morning.
My name is Jim Peterson, and I represent the Department of Children and Families. For a few things I want to address that just came out in this argument, a few of them, like, for example, there were mother suggests that there should have been these unsupervised or overnight visits after visits resumed. But this is a case where even when there were visits and they were supervised, mother was still at least 3 times dozing, falling asleep while holding the child, and one time was completely asleep. She was there with father at the same time. They were and father was trying to wake her up, shaking her, and couldn't wake her up. The visit continued because father was still there, and she just laid asleep. But this is what mother was willing and able to do at an actual supervised visit when somebody was there.
Well, the great majority of visits, she was portrayed in a positive light. Would you say that?
I would agree that most of them went well. There were some missed visits, but also some that DCF had to cancel because of exposure. And there were some comments. There were certainly some elements that were concerning, such as mother's inability to deal with to calm the child down. And she wouldn't even buckle her into a child seat because she just couldn't handle child screaming, and instead pass her off to the social worker. But for the most part, I would agree, and as well fairly consistent until we get to before trial. And that's another thing. We're a month before trial, and mother just stops visiting child altogether. Child is less than 18 months old, and she's complaining now that she didn't get the visits, and she just stopped. She just stopped entirely. And on those 2-hour visits, I would like to point out, mother says that that's inadequate, there should have been more. Nobody told the department to do it, mother didn't ask for it, and the department itself said, wow, for the last 4 months, these have not been great visits. Not a good situation, nobody was happy about it, including the department, and recognizing, testified in here that that's, I can't remember the exact language, certainly less than ideal kind of visit, and try to make up for it by doubling the amount of time mother had, and for nearly 9 months, that's what happened. And that was without any prompting, without any request. That's what the department did. The department tried to make up for this as best as it could with the tools it had, and it certainly wasn't about to just turn child over to mother when mother was still having these issues. And in fact, for unsupervised visits or for overnights. She couldn't even remain sober long enough to get into a inpatient treatment facility to get the one to accept her in. The one time when she did have a chance, which also came up, was very well anyway, she had more, but when she was in the hospital right after the birth, and the department helped and arranged to get mother into Stepping Stone, which was inpatient and would allow for reunification with child. The department was not willing to go right out and say, yeah, you should be reunified with child right now. After all, mother had been using not only through the pregnancy, but right up to delivery. Child was born substance exposed and in need, traumatic. She had to be intubated in the hospital for 10 days, difficulty breathing, crying, couldn't be consoled, had to go through a withdrawal. So this is a serious situation at that moment. It is not not stale at all at that point. And the department wasn't willing to say, yeah, we'll reunite you right away. They wanted mother to get into, social worker wanted mother to get into this treatment program, to begin to get a little effect, have some sobriety, and then the plan was to reunite. And that was, from the testimony, it's clear that that was made clear to mother, and then mother didn't do it. Mother refused, just left the hospital instead, even though that made her homeless. And that's another aspect of all these things that mother's complaining about. That one move of mother's, the department can't force mother to go into a place like this, and that one move affected all of these. That was set up for, it would have given her stable housing, which she didn't have at all through the course of this. It would have given her the substance abuse treatment. It would have also given her the access to other kinds of treatment, as the judge noted. This is kind of an all-in-one, there's all kinds of things available there. And it would have allowed her to reunite with child. And she's the one who left the hospital, and not DCF that pushed her or refused to do this. In fact, DCF did try, continued to try to help her in those areas as well. And mother did get into that other, again with DCF in October, that helped her get into Stepping Stone, and unfortunately there was a conflict with a particular person, and it still got her into a different one in a nearby city, and mother just failed to show up. In fact, mother, and again, it goes to going to mother's argument that she was close. She just needed, effectively saying, you know, she's close, she just needed a little more help. But mother got into several treatment programs during the course of this on her own, which is an issue itself that I've raised in my brief. But you know, there was this in August. She got into ad care in August of 2020. Then DCF helped her with Stepping Stone, where she actually, we know she entered. DCF was involved with that a few months later in October. Then in February, she got into a place, Bournewood. She got into another treatment program, which was an inpatient one in Stanley Street program in April of 2021. And a few months later, an unspecified program in June. And she couldn't complete any of these. So even with her ability to get into these programs, she simply could not complete these programs, remain sober, stay there, which really was a prerequisite for any sort of reunification or upping this contact, especially unsupervised, when we know that mother had been a long-time user, not only through this case, but for years. Mother was open and honest about a lot of her use and abuse, heroin and cocaine and methadone, obviously methadone because of treatment, but cocaine in every one of her prenatal screenings she was positive for, including at delivery as well. Regarding Justice Shin's questions, don't our case require motions to raise these issues? I don't know if a motion itself is required, but there has to be something to alert someone that this is an issue. You can't just come into court, and I think this is a great example of why those cases like adoption of Gregory and adoption of West say it's not just a preservation issue, but you need to give somebody a chance to actually do something. You can go to DCF and say, hey, this isn't enough, and DCF may solve it. It may be done, and I would suggest that raises it.
Right, so when I said motion, I didn't mean formal motion, but
but something.
It's enough to raise it outside of court?
Well, no, I don't think it's, I think it would be a trialable issue. I don't think it is, certainly under the cases. It's got to be raised.
Raised somehow in court before the
However,
judge?
I think if this were, I think this would be a different situation if mother, in general, if it didn't make it into the court, but mother had actually been pestering the social worker.
There's an administrative process, right?
Pardon?
There's an administrative process through which it can be raised, is there not?
Well, it can even just be directly to the social worker. And then, yeah, I mean, you can certainly.
I mean, saying it verbally to the social worker, is that enough?
Well, I think that you would have to, I do think you would need to raise more.
What if counsel for mother sent a letter to DCF or sent a letter to the social worker?
And I think this is where if you start to get a little more, this is a problem.
Preserve the issue for trial?
I think it would be an issue, but I think at the same time, if DCF said, no, this is unreasonable and didn't do it, and counsel didn't go further, that it still would fail under the case law, which fortunately is not this argument. But I do think that puts it in a different position. This is a case where the whistle is blown at the end of the game, and the coach comes on and says, yeah, but they were offsides in the second quarter. It's too late. You can't do it. You can't change it now at the end of the game. You got to do it while it's happening. Nobody had anything at that time. And that is, and it is, again, George and West, I think, are the two that I cited in my brief, and they are clear. This is why you have to do it, so that there isn't, somebody has a reason to do it. And in fact, in this case, with respect to the housing, I'll note that there was a lot of testimony. The social worker, not a lot, but there was testimony. The social worker was talking to mother about housing. And do you need help? And mother was saying no. Do you need help with this? Mother was going to try to get into a program. That was the plan. That was the plan for the substance abuse and for the housing. And it was a communication. So this wasn't like DCF's just doing nothing. You're on your own. The social worker was saying, how are you doing? There was frequent communication, according to the testimony, and I think in the findings. And this was part of what they were talking about. And it wasn't until it was too late before mother actually really said, you know what, this isn't working, and I need help for housing. And unfortunately, it was just too late for the department to be able to assist, because housing is, as we all know, there's a housing crisis for low income, and it's just difficult to do it at that point. But if I see my time is up, if there are no further questions, I'll rest on my brief. Yes.
Is your position that mother waived her right also for reasonable efforts as to the visitation?
I think that she raised it, but
At trial or before trial?
she only raised it at trial, and really, as I read it, really only solidified that argument at the end of trial, and really only as to the issue of was video visitation real visitation or not. And I think Thaddeus precludes that argument. And in mother's defense, mother makes an argument about that. Thaddeus came down after mother filed the brief. I just want to make it clear. I had the advantage responding with Thaddeus, but mother did not have the advantage when she wrote the brief. So I think they raised it. I think it's legitimately before the court, but then you get into, as Justice Shin's issues, but it wasn't raised ahead of time when anybody could actually do anything about it.
In about 2 weeks after the minor's birth, there was a temporary custody hearing, correct? The mother stipulated, the father stipulated.
That's correct.
And during that hearing, the judge encouraged him to push for visitation.
Pardon?
As part of the colloquy, the judge encouraged them to push with DCF for things like visitation.
I don't recall that.
And then after that hearing, there were a number of different hearings before the trial date, and it was never raised, correct?
That is correct. Admittedly, a lot of these were remote for a while, but they were still hearings and still represented by counsel. And so, yes, there were plenty of opportunities to raise it up to the court, and plenty more to at least raise it with the department. And
Thank you.
nobody.
I think we're going to have to leave it at that.
So that's good. Thank you. Your Honor.
Thank you very much. We'll now hear from Attorney Taylor.
Good morning.
Good morning.
Excuse me. Susan Taylor for the appellee child. May it please the court. On behalf of the appellee child, I urge the court to affirm the trial court's decision. I think it's clear that there was clear and convincing evidence that this mother was unfit. She had ongoing housing instability, substance abuse issues, mental health issues, domestic violence issues, all of which were not addressed during the some 18 months that this child, before this case went to trial. My client came into care when she was 11 days old. She has, she has been in her pre-adoptive home since she was 4 weeks old. She will be 3 years old in February. She is bonded to her adoptive family. I think that it's quite clear that the court acted in the child's best interest by terminating parental rights and freeing her for adoption. I would also argue that the judge didn't abuse his discretion in not ordering post-termination visits. In this case, the child is not bonded to the mother, and the adoptive family had indicated a willingness to allow mother to visit the child. And I would urge the court to affirm the trial court's judgment.
Thank you very much. These are difficult cases, and we appreciate your thorough briefing and excellent arguments. The case is submitted. Our next case is docket 22P263, Gill versus Armstrong and another. We will hear first from counsel for the appellant, Attorney Perkins.
Good morning. May it please the court. Matthew Perkins for the appellant Edward Gill for the estate of Anthony Gill. This appeal presents two distinct issues for the panel. One, did the Superior Court err in construing the Massachusetts Tort Claims Act, specifically Section 10J, when we assert this is a negligent maintenance of public property case, which is an exception to that. And the second issue is whether the Superior Court impermissibly dismissed the case for failure to plead willful, wanton, or reckless conduct. As I'll state during this, I think in this case, the court did a lot of fact-finding. The court relied on extrajudicial materials that I acknowledge we presented in opposing the motion, but the court didn't rely on all those materials, specifically a key fact in which the defendant, Peter Armstrong, said, when I bought this property where the accident happened, this cable was there, the town of Marshfield owned it.
So as I understand your argument, you are not claiming that the judge converted this to a summary judgment decision, correct?
Correct, because, and I thought long and hard about this. In order for the court to do that, the court would have had to tell the parties, I'm converting this to a summary judgment decision.
So if it's not a summary judgment decision and it's a motion to dismiss that we reviewed de novo, my understanding then is that we are bound by the four corners of the second amended complaint here, correct?
I would say that if you're reviewing the judge's decision de novo, the judge relied on materials beyond the four corners of the complaint.
I don't think we review a judge's, well, you tell me. Are we reviewing the judge's decision or are we reviewing the motion that is before us?
I'd say it's a bit of both. In order to review the motion, you have to know what the lower court ruled and what they found and how they arrived at their decision.
On a motion to dismiss, we don't look at findings. We look at the four corners of the complaint.
Correct. And I also would say then that the court can also look at the docket where these things were filed prior to or part of the record that was before the Superior Court judge. Because of the way the case was presented to the court, the two motions, our motion for real estate attachment, the town's motion to dismiss, arrived at the court at the same time.
So let me ask it to you this way then. If this was not a summary judgment motion, if this was not decided as a summary judgment, what authority allows us to consider anything beyond the complaint? What legal authority gives us that ability?
I would say that that the affidavit is part of the record and the court is allowed to consider matters of record in ruling on the motion to dismiss. But I'd say even without that, you have in our complaint, and I've referenced it in our brief, we have multiple allegations that the town of Marshfield failed to properly maintain the property.
I'm sorry, before you get there, if we consider the affidavit, don't we have to consider all of the affidavit, including Armstrong's statement that he told the town that he never gave permission for ATV riders to come onto his property?
Certainly.
All right, so if we accept that as true, that he told the town, they're not allowed, I have not allowed them to ride on my property, doesn't that undercut your claim of recklessness?
No, because our allegation is that he in fact told the decedent and other people that they were allowed to ride it.
Right,
So
but
it's-
he says in his affidavit that he did not, he told the town that he did not give them permission. So if the town doesn't have knowledge that there are ATV riders riding on this property, how could their conduct be reckless?
Well, I think that it's a question of fact. We have an affidavit, I think our complaint is detailed as to what we say happened here. That people use this area to ride. The town was on notice, given Mr. Armstrong's affidavit, and the allegations of our complaint that people were riding back there, and people have been riding back there for years, and that the town had taken steps to actually control the property, but they didn't go far enough. I think what the emphasis of our argument is that the town is an owner of land. The exception is that the owner of land is treated as a common law owner of land. So they had a duty to maintain the property safe, and they didn't do that. They allowed this cable to remain for 18 and a half years. In fact, I was sitting here thinking about it. We have the right-of-way. We have the trees outside the right-of-way where the cable was hung from. Again, we have multiple issues of fact as to what did the town know, when did they know it, what action did they take, or what action didn't they take. What we do know is that on April 29th, 2020, the cable was up, Mr. Gill rode his ATV into it and died. That we know. We know the town owns the property. We know that Mr. Armstrong has a right-of-way in the property. But these questions about what ATV riders used it, who used it, what was the frequency of the use, who knew it, these are all questions that should be hashed out in litigation and not on a motion to dismiss.
So let's focus first on the 10J issue. If we go strictly by the complaint without looking at the affidavit, it strikes me that you have a challenge, and we have not made any decision on this case yet, but it strikes me that your challenge is demonstrating that the town originally caused the condition. Just looking at the complaint.
Correct.
Without looking at it more.
Yes, I understand that.
Then you have the Armstrong affidavit, which at paragraph 5 states, and I'm going to read from this so I don't misquote, "At the time I purchased the Ferry Street property, there was already a cable attached to the 2 trees within the right-of-way," end quote. That's at Record Appendix, page 61. Is that statement the same as an allegation that the town put it there, or was the original cause, or is it not quite there?
I would say that if you combine that with the fact that the town was the record owner of the property prior to the time Mr. Gill took title to the property, it raises the inference that, yes, it was there. At a minimum, it was on the town's property, and they didn't do anything about it, where they could have done anything about it. And I'm not saying in the municipal capacity, which I cite in my brief, but as a private landowner, if you have someone conducting something dangerous on a right-of-way, you can say, stop that, remove that. They could have gone so far as to cut down those trees as a private landowner, not a town. And then if you couple that with the fact that they're a town, they have the administrative authority to compel the removal of these things. They did it ad hoc. They had the fire department say, oh, don't do that. They knew, they took no action.
But to be an original cause, it has to be an affirmative act. So how is a failure to remove it an affirmative act?
I would say that again, if we're looking at the original cause, it was there, they owned it, so I'm sticking to that it was on the town's property. I say they're stuck with it.
As that exception has been developed in the case law, the original cause must be an affirmative act.
Correct.
And you're saying that the failure to act is an affirmative act, which could not be right.
I'm saying that the maintenance, as the term has been defined in the case law.
Maintenance is something different, but
Right.
if we're talking about original cause, where is the affirmative act?
I would say the maintenance of the cable. And again, we have fact issues which we'd like to explore as to who, what, when, where, and why as to this cable, which had been on town property for 18 and a half years.
So maintenance, as we said in the Moore case, means upkeep of existing structures. You're not saying that the town failed to maintain the cable in a good condition, right? Which is normally how we see the negligence maintenance cases play out. You're saying they should have removed it. So how do you fall within negligent maintenance?
I say they allowed it to exist. They took, I understand we're cutting hairs, but it was there, it was on their property. Armstrong took title to the property, it was already there. They allowed it, they maintained it, continued to allow it to exist for 18 and a half years. We know they knew about it, we know they took some action
So
regarding
it's
it.
negligent maintenance because they maintained it?
I'd say it's negligent maintenance because they allowed it to exist. And again, because we're on a motion to dismiss, we haven't had any discovery as to this, which is really one of our points here is, again, we don't know because we haven't gotten that far.
I just have one final question. I think you answered it, but I just want to make sure that I understand your argument. Our ability to consider the Armstrong affidavit at the motion to dismiss stage is predicated on what? I'm asking you. It's
Yes.
probably a poorly phrased question. Do you understand
No, I
what I'm
understand your
asking?
question, Your Honor. And it was better briefed in the lower materials, and in fact, because the trial court considered it, I kind of steamed ahead and said, well,
Sure.
he considered it all except for this key part. And again, the fact that it was in the record, the trial court record, at the time of the hearing on the motion to dismiss, it was part of the record, I'd say that allowed him to consider it.
Okay. Because
It wasn't an affidavit that was submitted.
it wasn't attached to the complaint. It wasn't an exhibit to the complaint. It was
No, because-
filed in opposition to the motion to dismiss.
Well, the affidavit was filed in opposition to a motion for a real estate attachment.
Motion to opposition
which
to
we
the
had
motion for real estate
filed,
attachment.
I
That's
believe, prior to the motion to dismiss, but because of 9A and time to respond,
Sure.
it all kind of arrived on the Superior Court's desk at the same time. So we were working up our motion for real estate attachment, which had a volume of factual material, which the court relied on. They relied on my affidavit, in which they were talking about how the cable was slack or not slack. They relied on Armstrong's affidavit, except for what we considered to be the pivotal point. And I think most of these cases, except for the case in which the people broke into the school and murdered the person, they're all summary judgment cases. There's a fully developed factual record for these cases. We don't have that here. And in fact, my key argument in the reckless case for the recreational statute is the judge found facts. He looked at Mr. Gill's knowledge. He didn't look at an objective criteria as to how this cable could seriously kill somebody. And he compared it to the Ali case, which is a bicycle case on a public property with a visible gate in the city of Boston, not a wooded trail where ATVs drive around. So I think the harm and the willful wanton, he didn't consider that. I think it's objective. The court didn't consider the objective criteria for that. And he found facts. And the willful wanton is important because we have claims against Mr. Armstrong. And there are serious questions of fact as to that. And I don't think that should be allowed to be stayed. Even if the court says you're right, it wasn't originally maintained, our argument on that is it was pled for willful wanton conduct. The Inferna case basically says that. The appeals of this court said that
I'm sorry, what case did you just reference?
Inferna versus Sudbury,
Got it.
in which the exact same thing happened. A snowmobiler was traveling on some trails, they hit a cable, and the guy died. There's cases all around the country where this happens. The courts all say this is reckless conduct. And at this stage...
But if we agree with the judge that this case doesn't fall either within negligent maintenance or original cause, we don't get to that issue, right, of recklessness?
That's up to the panelists, whether they want to consider it because of the underlying litigation. That's why I'm saying it's important.
Reckless or not, if it wasn't negligent maintenance or the original cause, then the town is immune, right?
That is correct.
Okay.
But I would say that the issue of recklessness is important for the litigation that's ongoing because it's going to be an issue in that case. And I believe the court was wrong in finding facts, applying the proper standard, and failing to credit our complaint, the allegations of our complaint. He basically said, well, Gill knew this cable was there. He himself was negligent and he should have taken care. Well, that's not a motion to dismiss. I don't even think that's a motion for summary judgment. I think that's a question of fact for the jury. But we're not there. And I also think the recreational use statute, and again, this wasn't briefed, but what is the use of this trail? It's a right-of-way for a private landowner. It's not for recreation, although Gill was using it for recreation. I'm not saying he wasn't. But what is the scope of that use? And can you have a recreational use for just a group of people? We don't know where it extends. I think, again, lots of factual issues on these things that need to be developed during discovery. Panel has
Seeing no
any
further questions, thank you very much.
Thank you.
Now hear from Attorney Amos for the defendant.
Good morning, Your Honors, and may it please the Court, Justin Amos on behalf of the Town of Marshfield. I'd like to narrow in on two things that came up during argument today, the first being whether the Armstrong affidavit can be considered. It categorically cannot. There is no authority that was cited in the trial court. There's no authority that was cited in my brother's brief.
What's the controlling authority?
The controlling authority, I'd point to Gulchin, which is cited at footnote 7 in our brief, as well as a published opinion reversed on other grounds by Justice Rubin, that you look at the four corners of the complaint and any attachments thereto. There is a limited subcategory of documents that can be considered beyond that, like documents that are expressly discussed and therefore deemed incorporated within a complaint. Public records, which are subject to judicial notice, can be considered in the complaint, or documents that there's no, that were on notice to the plaintiff and there's no reasonable dispute as to authenticity. That simply does not apply to the Armstrong affidavit, which I believe, as Justice Shin had noted, was submitted in respect to an entirely distinct motion, which is a motion for real estate attachment.
So what do we do to the extent that the Superior Court judge did consider it?
I think I would rely upon the Cruikshanks case, which is that this court can affirm for any reason that's readily apparent upon the record. And I believe that was part of the colloquy you were having, Justice Nyman, with my friend, that you look at the judgment that was entered by the lower court. You can depart from the analysis, from the specific bases, from the cases that are cited by the lower court, but you are not bound to adopt the reasoning or to tread the same path that the trial court did. And I think that's especially important here, where my brother conceded what I think was implicitly conceded in his brief, that he is not challenging that the judge should have or improperly converted this to a motion for summary judgment. I heard him state this morning that he agrees that this was a motion to dismiss. And if that is true, then the lower court could not consider the Peter Armstrong affidavit within the context of a motion to dismiss. One other thing I wanted to correct, my friend had stated this morning that all of the cases were summary judgment cases, and that's factually and legally incorrect. All cases we cited with respect to 10J, Brum, Kent, Jacome, Cormier, were all motions to dismiss, all motions at the Supreme Judicial Court. The two cases cited by my friend were summary judgment cases, and of course the Moore case was a summary judgment case. But as Brum expressly directs, lower courts should deal with questions of immunity from suit at the earliest practicable time, and if possible before discovery. Because if an immunized official or an immunized party is forced to go through discovery, then the purpose of the immunity from suit is undercut. So with that...
So you filed, I don't know if it was you personally, but your client filed a motion to strike the affidavit, and the judge denies it as moot in light of the decision on the motion to dismiss. How do you interpret that? Does that mean that the judge did consider or did not consider it?
I think it is less than clear. It was not me in the trial court. It was my firm, but I was not trial counsel. The judge from the docket indicates that no action was taken on the motion. The endorsement on the motion itself says it's denied, so I think it's a little bit unclear exactly what the Superior Court did with our motion to strike.
But it wasn't stricken. It says no action taken.
Correct. The affidavit was not stricken, and I think that the proper procedure would have been to make it explicit either in the decision or on our motion to strike that either I am considering this affidavit for substantive purposes and therefore converting, in which case we would have been given the opportunity to come forth with our own evidence, or I'm striking and I'm not considering it for substantive purpose. This is 12b-6. And while the judge did not make that expressly known in the decision, I think especially with respect to 10J, I think it's less clear with the rec use, that the judge was not considering the affidavit for substantive purposes with the 10J argument. I think it truly was for context. The fact that the judge, who had been presented with the information that if you consider this, it's conversion, the opinion itself still relies on the 12b-6 standard. And we were not given an opportunity to come forth with additional evidence. And while that, I think, was less than clear from the opinion, this court, of course, can affirm for any reason that's readily apparent upon the record.
If we agreed hypothetically that 10J immunity applied, do we still go on to address the recreational use statute?
I don't think it's necessary for the court to do so. In its discretion, I think you can reach it. If we are immune under 10J, it's irrelevant whether we're exempt from liability under the recreational use statute, and typically the courts don't like to issue advisory opinions except where the issue is likely to repeat itself or raises substantial issues of law that are not as well settled. So I would suggest, hypothetically speaking, if the court were to affirm on 10J that it's unnecessary to reach recklessness. I take my friend's point that it could affect in some way the continuing litigation against Peter Armstrong, that there's a judicial decision that there was no recklessness, but I think that applies only to the town. I don't believe that there's any res judicata. I don't think that raises law of the case doctrine if the case would be affirmed, restrict issues.
Why is there not a question of fact as to whether or not the conduct here was willful, wanton, or reckless? It's always important to note that it's an or, not an and in the statute.
It absolutely is an or. I think I will concede my argument on rec use is nowhere near as strong as my argument on 10J. I think if you look at the Sadler case, which admittedly is a summary judgment, but discusses this as a matter of law, that the facts that were adduced at summary judgment in Sadler are extraordinarily distinct and of a degree of magnitude more serious than the facts that are alleged in this complaint. And the SJC concluded that those facts do not amount to recklessness as a matter of law, not as a matter of fact, but as a matter of law. So I think you can, applying that, although I acknowledge it is on a separate standard of review.
You don't have a motion to dismiss case that says the same thing, a 12B6.
I do not, Your Honor, and I think that is likely because rec use is rarely raised at motion to dismiss because the other factors are usually in dispute. Whether the particular use that the individual is putting to the land was recreational is very rarely pleaded in the complaint. It is pleaded in the second amended complaint by virtue of incorporating the presentment letter, which was served on the town of Marshfield, which states that the property was being used by ATV riders, and it's very rarely pled in the complaint, which is done by incorporation of the presentment letter, that there was no fee charged for the use of the property. So this is a unique circumstance in which I think it was proper for us to raise it. Whether it was necessarily a winning argument, I think is in the eye of the beholder. But I think it can be raised at a motion to dismiss when the record permits that. And it's rare that the record is so explicit as to the other factors of the recreational use.
Was there anything precluding, I'm back to 10J now, although I suppose it applies to all counts. Was there anything precluding an amendment to the complaint at the time the motion to dismiss was filed? So, for example, the Armstrong information comes to light. Anything precluding, I suppose at that point in time, it could not be done as of right. That's
correct.
It's a discretionary call by the lower court judge, correct?
Correct. Because we had not yet been joined, we had just been joined at that point, I'm not sure if the tracking orders, just understanding order 1-88, if the tracking order for amendment had already passed, but of course any party is permitted to file a motion for leave to file outside of the tracking order.
I quarrel with that because you didn't file an answer, right? You just filed a motion to dismiss.
Correct.
Then isn't the plaintiff allowed to amend as of right?
I don't believe so, Your Honor, because an answer had already been filed, so a responsive pleading had been filed within
I think that applies only to answer. So let's assume that the plaintiff had the right to amend because there's no answer filed.
Sure.
Is that a way for us, for the judge to consider the affidavit, given that he didn't strike it?
No. So I'll answer that in two parts. Assuming that the plaintiff could have amended as of right in response to our motion to dismiss, the judge would have been able to, there would just be an amendment. There would be no consideration by the judge of the affidavit if the plaintiff had filed what would have been then a third amended complaint and attached the Armstrong affidavit to that complaint, thereby incorporating it, or added paragraphs that essentially stated what was in the Armstrong affidavit, then I think it is appropriately.
The proper thing would have been to actually file an amended complaint, but could the judge not just consider it functionally as an amendment to the complaint, given that the plaintiff had a right to amend the complaint?
I don't believe so, Your Honor. I'm not aware of a case that has expressly addressed that issue. It's certainly not raised. Either it was not raised in the trial court, it was not raised on appeal, and I understand my friend's argument to be that the affidavit can be considered regardless of whether it was attached to a complaint or was amended in a complaint, so I think that's splitting hairs with what my brother's presenting today. I think in a hypothetical situation, had the judge in their decision said, I'm taking the submission of this affidavit as a de facto amendment, I think it's very likely we would have cross-appealed. There's no authority that I'm aware of in this context that permits the judge sua sponte to consider extraneous documents submitted in an opposition to a motion to dismiss as a functional equivalent of a motion to amend. And although it wasn't brief, so the exact case escapes me, you typically, when filing a motion to amend or an amended complaint, you have to attach a copy of the proposed amended complaint so that the judge can determine whether it's futile. So I think that's a procedural quagmire we don't need to reach because it's not something that was raised in the trial court. And so to the extent that it is implicitly raised by my friend's argument today, it would be waived. If there are no specific questions, I'll turn just briefly to the 10J argument. I heard specifically with the colloquy with you, Justice Shin, my friend does not raise a single affirmative act that the town took. It's a failure to do things. And as the Supreme Judicial Court said in Kent, as they said in Brum, as this court said in Moore, the fact that there's a laundry list of things that the town could have done to remedy this alleged situation is proof in the pudding that this is a failure to do something. We could have had the Board of Selectmen issue some kind of order. We could have had the Concom issue an enforcement order. We could have had X, Y, Z. That is evidence of the fact that this is an omission, not an affirmative act.
How has our law evolved to that when the statute itself says any claim based on an act or failure to act to prevent or diminish the harmful consequences of a condition or situation, and it goes on. How have we gotten so far from the statutory language?
As the SJC acknowledged in Brum, which is, I believe, the first case to address 10J after it was adopted and incorporated into the Tort Claims Act, this Section 10 specifically, but more specifically 10J, is inartfully crafted. It is not well written, it is confusing, the language that is used makes very little sense grammatically, but we are bound at this stage by what the SJC has said repeatedly. Kent, Cormier, Brum, you have to state an affirmative act, and a failure to act, an omission, is not sufficient to be an affirmative act. And I think, although the individuals on the second floor might want to change that down the road, I think we're bound by that announcement, that unbroken line of SJC cases going back to 1993 in Brum, and Cormier most recently, I believe in 2000, reaffirmed that. It must be an affirmative act, not a failure to act. So given here that there is no affirmative act, we then move to whether the 10J3 Savings Clause prevents the application of immunity here. And I think as Justice Shin, you acknowledged in the colloquy with my friend, negligent maintenance in every case that I've come across and all the cases that are discussed in the briefing contemplates a situation where the public employer either installed themselves or have approved of or tacitly approved of the equipment or the structure or the improvement to land itself. If you look at the two cases that my friend cites, the Twomey case, it was abundantly clear that the stop sign at issue was installed by the Commonwealth, and that pursuant to Chapter 82, Section 3, there was a duty for the Commonwealth to both install the stop sign, but also to inspect the stop sign, and that was negligent maintenance of public property. And I believe in the Nguyen case, I don't know if I'm pronouncing that correct, which, as is noted in our brief, predates Chase versus Curran, so I don't think it's even persuasive value. There was no dispute that the town had installed the alleged dangerous condition itself in Greenwood. There was no dispute that the town had installed the telephone poles that were used as a parking barrier outside of the school, and therefore the maintenance was of something already constructed by the public employer. And I'll acknowledge that Moore doesn't say that specifically. Moore, I think, quite clearly deals with my brother's argument that the general upkeep of public property in a safe manner is not within 10J3. And that's, I think, quite clear, quite explicit in Moore. I think it's the logical extension of that second portion of you have to maintain contemplates the maintenance of something already constructed, it must be something already constructed by the public employer themselves and not something that was constructed or placed by a third party. And as my time runs out, I'll note just briefly, if the court is to consider the Armstrong affidavit, it does not, I don't remember if it was Justice Shin or Justice Nyman, there's no link then to say that it was the town who installed the wire cable. It could be just equally as likely that another third party installed it.
Okay, seeing no further questions, I thank counsel for both parties. This is a difficult and a tragic case, and I will state that the record should reflect that both parties have received excellent representation in this case, and the case is submitted.
Thank you, Your Honors.
Our next case, docket 22P64, Bonilla versus Bonilla. Counsel for the appellant, I believe Attorney Long.
Good morning, Your Honors. James Garner-Long III for Oscar Bonilla, alongside here with Attorney William Alexikos. Welcome. Your Honors, I'd like to draw your attention to the language of this document, primarily briefed in argument number 4.
I'm sorry, I didn't hear that last part.
Primarily briefed in argument number 4 of our brief. The reason why is because, at first and foremost, we have to look at what my brother counsel, Attorney Kessman, had added after the filing, or in his filing to motion to dismiss, the separation agreement of the parties circa 2014. So in that separation agreement itself, it makes several statements regarding real estate. There's one statement that says that the parties do not have any real estate, but they do have real estate that is encumbered. But it is not encumbered, and it is encumbered to the maximum value of the property. There is also precatory language that the parties desire. They want to keep the property. But precatory language is not binding, it is just merely an expression of a desire. And there is only one reference to the purported restriction on alienation of this property. It is in Article 5, titled Personal Property, and it states that there is one personal property located at the address in question, and it does use the word house. My brother counsel, in his brief, many times talks about plain language, common sense, dictionary definitions. Real estate is not personal property, and it is our position that that restriction does not adequately apply to the real property at question. And therefore, it is neither unequivocal, it is ambiguous, and it is precatory, the restrictions that are in place.
What else could house mean?
It could be a dog house, it could be a bird house, it could be an outhouse.
I mean, it says personal property located at, and then gives the address, right?
That's correct, Your Honor. And
the judge had before him or her, at least at the time of the divorce, information regarding who resided at that house, whether or not that was real or personal property. Couldn't the judge at the time of this petition have made a reasonable interpretation that that was the house, that was real property?
I don't think that's anywhere on the record, Your Honor. I think that is what I believe is the kind of overarching issue with this, with the lower court's ruling, is that what has happened is there's been what I have termed the squint test, where if you squint far enough and look at it, it's fine. And that's what's kind of happened here is, oh, we should interpret personal property as real property and just chalk it up to the many, 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 many ambiguities and inconsistencies in the separation agreement. The judge could have also sent the parties back to clarify the separation agreement, which I have seen judges do on numerous occasions. But the judge allowed this to be entered in as the separation agreement of the parties, and it is very ambiguous and
So
inconsistent.
you think a jury should decide whether house means the house or a doghouse or a birdhouse?
Well,
mean,
I think that is a question
Can
of-
any reasonable jury really find that house means anything other than the house?
Well, Your Honor, I do think that it does reference specifically personal property, but I understand.
As you say, the agreement in many respects is completely internally contradictory. So, I mean, do you really think this has to go to a jury to decide whether house means the house?
I think that it is a question of fact.
You have a lot of, it seems to me, strong arguments here, strong in the sense that we need to give them a lot of consideration. I'm not sure that arguing whether or not the house is real or personal property is your best argument in your limited time.
Yes.
But your time is yours to see as you
Yes,
see
thank you,
fit.
Your Honor. So if this court finds that this restriction is related to the real estate, if we move on to what is presented as argument one of of the brief. First, I want to address that this court should review the motion to dismiss de novo pursuant to Cook v. Patient EDU LLC. And in that regard, we have to look at whether the restraint is reasonable against public policy and also precatory. So with regard to whether the restraint is reasonable or not, this court should look at the term. In Jackson v. Keating and Davey Hart, those are excellent cases. Jackson v. Keating, that restriction was for 24 months. Davey Hart, it related to high school graduation of children or remarriage by the spouse who is living in the property, residing in the property, ex-spouse, I should say. And those are definite time periods. In here, it is unlimited, it's unbounded, and it is coupled with Exhibit D, which relates to this being carried on in perpetuity potentially because it applies to the estates of the parties. So if the ex-wife were to pass away, there are 2 children, now you have 3 people who have to have unanimous agreement to sell. If they have children and so on, and we go on forever, there's nothing in here, although my brother counsel references or makes argument that it is just for the life of the parties. There's nothing in the document.
Doesn't state that.
That states that it is for the life of the parties. Also, there was an argument made at the trial court level that it was for 40 years because they had refinanced to take advantage of a lower interest rate. There's nothing in the agreement that says it's for 40 years. And so this is going on in perpetuity, potentially beyond the life of the parties. And for those reasons, this is an unenforceable provision in the separation agreement, and it should be stricken.
So this separation agreement was not, did not merge into the divorce judgment, correct?
That's correct, Your Honor. So it
So
survives.
we look at it as a standalone contract.
That's correct, Your Honor.
And that's why you couldn't move to modify the judgment because, correct?
Yes, that's right, Your Honor.
What about Section G of the separation agreement that says this agreement shall not be altered or modified except by an instrument acknowledged by both the husband and the wife or by further order of the court? Does or by further order of the court empower a court to review and modify the separation agreement?
We don't believe so because of it surviving as a independent contract. And also there is a provision that allows for provisions that are invalid or unenforceable to be removed without totally disrupting the entire contract.
Then why put an or by further order of the court in a contract? What does that mean here?
I believe that that is a method to modify, but typically that only applies that these contracts are they do survive as these independent contracts and cannot be modified, because there's case law that says that if this provision is as it is argued by the appellee, it is property division, and property division is final. But I do understand Your Honor's comment
Is the court referring to the court that is going to approve the settlement agreement and enter the divorce judgment?
Yes, I believe so, Your Honor.
Okay. Do you know how old the parties were when they entered into this agreement?
I don't know their exact age. I know that their children are now in their college
I think
ages.
their children were 17 and 25 when the agreement was entered. So we're not talking about two people who are of advanced age, right?
That is correct. They're both not incapacitated. One is a business owner who is our client. And so the provisions here raise major issues with regards to the fact that it is an unrestricted, unbridled restriction on alienation. Furthermore, there is the precatory language that they merely just wanted to keep the house, not that they were restricting it. But if Your Honor...
So the cases set forth the canon of construction that if there's a way to interpret a document so that it does not impose an unreasonable restraint, the courts should construe it that way. So, I mean, it's plausible. Is your friend's argument not plausible that the restraint could be just during the party's lifetime? And if that's plausible, is your position that it's still an unreasonable restraint?
I do believe so, that it is, because the life of the parties has been found in the past to be unreasonable restraint, although in other cases they have found that the life of the parties has been. But I think that interpretation...
Which case are you relying on? Do you have it?
I think it's in the reply brief.
Okay. I mean, it depends on a number of factors, right? But also partly on the age of the parties, right?
That's correct, Your Honor. And I don't know their precise age, but I believe they're in their late 40s, early 50s, if I'm not mistaken. So what has happened is that we now have a situation where, without resolution of this restriction could be in place indefinitely and in perpetuity, and that's why it is not reasonable.
So your central argument is that the contract is invalid and unenforceable, correct?
That's correct, Your Honor.
And you then go on to the conclusion that, therefore, partition is necessary, correct?
That's correct, Your Honor.
Is there something other than partition that a judge would be empowered to do? So let's assume, arguendo, that we agreed that the language of the separation agreement was unenforceable. Would a judge have power to do anything other than allow the petition for partition?
Well, at the divorce stage, there could have been a different division of assets.
I mean now, obviously.
But that's not available to the parties. And so now it is our position that they are tenants in common, and one party seeks to enforce his rights to alienate the property, and without the other's assent to that alienation, then a partition is the only action to divide that asset.
This is purely hypothetical, but let's say, could the judge say to the parties, before partitioning, I would give you an opportunity, let's say you wife want to stay at the house, assuming she lives there, and you can pay husband an amount equal to half of the whatever appraised value or whatever it might be. Would that be an option?
I think that's an option that could be dealt with in settlement, and there were settlement negotiations. I don't want to enter them as evidence here.
If it's not part of the record, then we can't.
And so, but there were settlement negotiations prior to and during the partition action before it was dismissed.
But you're saying your view is that the judge has no power to do anything short of allowing the petition?
Well, it is a court of equity, so they could deviate, but I believe under the partition, because it is statutory, the options are limited. Your Honors, for my final minute, I just wanted to bring up the issue of whether this is a motion to dismiss or motion for summary judgment. I rely mainly on my brief, but in that regard, the addition of the separation agreement as additional evidence would convert this to Rule 56, and we cite to the Stop and Shop v. Fisher case as well as Rule 56 itself.
Can't the judge take judicial notice of a court document?
The court can.
So is there any dispute that this is what it is, the separation agreement?
No, but there was also an affidavit from the ex-wife as well.
Okay.
That was filed. If there are no other questions, I'll rest on the brief and the reply brief.
I do. Moving back to the process, if this was a divorce in which the separation agreement was incorporated into, and your position is there's a faulty provision of this separation agreement, could you not move to vacate the judgment?
I don't think so at this time because of so much time has elapsed. Usually that's restricted to a max of a year unless there are special circumstances, and I don't know that this would fall on this. I think it's more that the property was not divided, and that's why we state that it's tenants in common.
But in the divorce action, the property was incorporated. Again, you might say it was adjudicated for that divorce.
Yes.
And does that not prevent a partition action?
No, it does not, Your Honor, because if you look at, I'm sorry if I'll mispronounce it, but it's Bernatavicius. They discuss that where asset is not divided, even though it is referenced, it's not divided, and that's our argument that effectively it wasn't divided because that clause is not enforceable.
Excellent.
All right.
Thank you. Seeing no further questions, thank you very much. We'll now hear
Thank you,
from
Your Honor.
counsel for the appellee, Attorney Kessman.
Yes. Good morning, Your Honors. May it please the Court, my name is Stephen Kessman. I represent the appellee in this case, Rosa Bonilla, now Naira. Basically, I'm prepared to submit on the brief that we filed for the appellee, but my understanding is that the court, unless I had requested it in advance and was approved by the court, that the court would not allow that. So I'm prepared to basically hit the high points on this case and summarize what we feel are the most significant aspects of it and why the trial judge was correct in denying partition and allowing the motion to dismiss that we filed in the lower court.
And to be clear, you have 15 minutes. You are not obligated to use all 15 minutes, and we will have some questions for you, but your time is yours to see as you see fit. But let me start out with a preliminary question for you. The relevant language of Article 5 of the separation agreement states, the house can only be sold or transferred by agreement of both parties.
Correct.
You state in your brief that this agreement, and I'm quoting from your brief, quote, obtains only during the course of his/her lifetime, end quote. How do you reach that conclusion? I'm not sure that the language necessarily supports your argument.
Are you referring, Your Honor, to the section that we're dealing with regard to the issue raised by the appellant concerning alienation?
Yes.
Restraint on alienation?
Yes.
We arrive at it by looking at the wording of the agreement. This agreement was entered into by parties who were getting divorced, Oscar and Rosa. The language referred to that it's binding on their estates doesn't bind anybody beyond them. What it refers to is as indicated in the brief, our brief, that it refers to the parties only. And even if it didn't refer, even if the court held that it would refer to the parties, and let me just say this, the parties only are the life and being at the time of the making of the agreement, the separation
The
agreement.
later provision about the estates says that the estates shall be liable for any obligations set forth herein. So why doesn't the restraint apply to the estate?
I'm not sure I understand the question, Your Honor.
Under the Article 8, General Provisions, sub B, that's entitled Death, it says, "This agreement shall be binding upon the estate of both parties, and such estates shall be liable for any obligation set forth herein." So why wouldn't the restraint on the alienation of the property apply to the estates?
It would not, apply to, it would not apply in this case, and let me just say that it would not apply because that was not within the contemplation of the parties at the time they executed the separation agreement. When the parties executed the separation agreement, they were looking only at their various lives and interests at the time of the divorce case. Now, I would also point out that, and that would be the way you would read a separation agreement. This is why we said in the brief, that we're talking about a common sense reading of the agreement. How do you apply this in daily life? Now, I would also point this out. One of the cases we cited was Fisher versus Fisher. In that case, it was decided by this court in 1986. The case basically says that if in a contract provision, one or more possible constructions of the provision is possible, the contract provision that's preferred, the construction that's preferred, is the construction that saves the contract, meaning that says that there's no restraint, no unreasonable restraint of alienation. And that saves the contract provision from being defeated. And that's the practical application that is used by the appellate courts. And this court decided that case, Fisher versus Fisher. In addition to that, there are numerous cases that are in accord with that stand that the court took in that case. And they're cited in footnote 5 of Fisher versus Fisher. And you can find them there. Also citing the restatement second of property and 6 American Law of Property, section 26.66, and the comments in the restatement, the various comments C and D, and several cases. But I will also point this out with regard to restraint on alienation. Obviously, and this kind of construction obviously would have been contemplated by the parties at the time that they executed the separation agreement, because it would make no sense to execute an agreement that you know is going to fail. Okay? So they didn't do that at the time, and therefore this court should understand, should hold that that in this case there's no restraint on alienation that appears straight on the agreement. But I would also say this: even if it was decided that that there was an unreasonable restraint on alienation in this case, even assuming that, that invalidity would not invalidate the entire agreement, because and that's in accord with what I just indicated from Fisher versus Fisher. There's a provision in our separation agreement which says that if a provision is held invalid, it doesn't invalidate the entire agreement. So if the court held in this case that there was an unreasonable, invalid restraint on alienation, that would leave the agreement, the rest of the agreement intact, and you would end up with what we said in the brief is the situation in this case, meaning the restriction on transfer of real estate, of the property, is binding only on Rosa and Oscar.
Okay, so let's say we agree with that. Let's say we accept your reading. We still have to determine whether this is an unreasonable restraint. So do you agree that the parties were not of advanced age when they entered into this agreement?
Parties were not of advanced age. The parties entered into this agreement, I think it was in 2014.
Right, and they were not, 80, 90 years old at the time, right?
Right.
Do you agree with that?
That's correct, yes.
Okay,
Yes, and the children were minor children at the time.
So the restraint could still be in effect for decades?
But it's within the life and being of the parties.
I understand, so I'm accepting your reading hypothetically, but theoretically then, the restraint could still be in place for decades. Do you agree with that? Okay.
There's no denying that, but it's valid, and it's valid under the law. It's not an unreasonable restraint of alienation, as the law of our Commonwealth indicates what is invalid. In this case, it's not invalid. So I would, unless the court agrees that I can submit on the brief, I'm prepared to sort of hit the high points of the case.
You may submit on brief. Your time is yours to use as you see fit. If you wish to submit on brief at this juncture, you may certainly do so.
Well, I'd like to sort of point out certain things that would basically refute my brother's arguments on this.
Still.
All right? The separation agreement clearly identifies the property in issue. How does it do it? It says 40 Manning Street, Roslindale, Massachusetts. That can't be anything but real estate. It's a house with an address. Okay? So, as clumsy as this agreement was drafted, and as your honors can see that from reading it, and I wasn't involved at the time of the divorce, so it wasn't me that did it, but in any event, it's still a valid agreement. In Exhibit D, which relates to that property, it says the parties want to keep the house. The intent of the parties governs, and their intent is clear from this language. Okay? And the parties' intent determines the extent of their agreement. And again, the separation agreement, by its terms, was not merged into the judgment of divorce. But it survived the judgment of divorce and retains independent legal significance as an enforceable contract. This separation agreement was approved by a probate judge as fair and reasonable, and in the words of the judgment, quote, survives the judgment of divorce and remains as an independent contract, end quote. I would point out the survival provision of a valid separation agreement cannot be changed by the court. and there's case law on that. We cited in our brief. In view of the status of the separation agreement and the fact that it fairly reflects the intent of the parties with respect to the 40 Manning Street, Roslyn Dale property, Oscar cannot have partition of this property because the disposition of the property was adjudicated in the divorce action. And that holding was made in Bush versus Bush. Also, there are several legal theories that can be used to reach that conclusion. There's issue preclusion, there's collateral estoppel, there's res judicata. We cited a case called Heacock versus Heacock, a 1988 case, and I would point out to your honors that in footnote 2 of Chief Justice Hennessy's opinion in that case, he explains these terms very clearly, what they mean. What I want to say is, whatever theory we use in this case at bar, the conclusion is the same. There can be no partition, none. Now, issue preclusion, which is also known as collateral estoppel, was the basis of the land court's decision in Jackson versus Keating to find that the court lacked subject matter jurisdiction to grant partition, and on facts very similar to the facts in the case here at bar between these parties, and they allowed the defendant's motion to dismiss. So in that case, the defendant did exactly what I did in this case. When I got it, I filed a motion to dismiss. And the motion was allowed. The motion was allowed there in Jackson versus Keating by Judge Spiker in the land court, and was allowed in this court by Judge Rivers in probate court in Suffolk. In the case at bar, what I want to point out, and this relates to arguments my brother has made in his brief and what he's stated here today, the result is the same whether you have a motion to dismiss, whether you treat the motion to dismiss as a motion under Rule 12b-1, or whether it's under Rule 12b-6, or whether you have whether you're doing it under a summary judgment, Rule 56 motion.
And I'm sorry, but your time is up, so I think we're going to have to end there.
Okay.
But let me thank both parties for their excellent arguments, for your helpful briefing, and the case is submitted, and we stand in recess. Thank you very much.
Thank you very much.